Good afternoon, everybody. Thank you for attending. This is Work Visa Options for Students Life After OPT. My name is Fuji Whittenburg, and we will be getting started with the webinar now. I hope everybody's doing well. A little bit about myself. I'm an attorney here at Wolfstorff Rosenthal LLP. We just had a name change in case anybody has noticed. I am here in the Santa Monica office. We also have a New York office as well. We specialize in immigration law, and you know, we're going to go through basically what all of the options are. And I just have to say, obviously, this isn't meant to be direct legal advice. It's for informational purposes only, and each situation varies, and the facts of each case varies as well, so that'll obviously impact your options. So I just wanted to say that ahead of time, but beyond that, I hope you do find this useful. We'll go ahead and get started. Just some quick information, some recent updates. The paperless I-94 cards, it's almost in May, it'll be about a year, so I guess it's not as recent anymore, but for those who have not traveled since last year, they are doing away with the white paper I-94 cards that were previously stapled into your passports. And now it's paperless. They're pulling the information from the manifest records, and they're accessing electronic travel information and inputting them into their database. Usually, you know, and it's only at the airports right now. So land border's still getting the I-94 card. You know, we've had some reports that people are having a hard time accessing it, so it may be a day or two before the information is updated. So you do need to go to the website provided here. It's www.cbp.gov/I-94, and you can actually print, download, save, you know, whatever you want to do to access it there. And you also want to make sure that the information is accurate. And for those of you who are, you know, needing it to show proof of status or for your driver's license or whatever it is, you can get it there. Okay, so there's CPT and OPT, which a lot of you are obviously very familiar with. And CPT is curricular practical training. That's when you want to basically work or have an internship while you're in school, and it's 4 credit, or it's if you need work authorization for some sort of an internship while you're in school. And then OPT is optional practical training, which is 1 year post-graduation. And that gives you basically 1 year of work authorization. The training has to be in your major field of study, and it allows for basic full-time employment for that year after graduation. And something to note, even though your I-20 is endorsed, or let's say you apply for OPT and you haven't received the card yet, or if you've received the approval notice and not the card, you do need to wait for the card to start working. The approval notice should be okay because the dates should be on there, and you want to make sure your I-20 is endorsed for employment. So that's something to do with your OPT. For those of you who have degrees in the STEM fields, science, technology, engineering, and math, you are eligible beyond the 1 year for an additional 17-month extension of your OPT. So that'll give you about 29 months total, which is great. It's a huge gift from immigration to you. There are some conditions to having the STEM extension. Obviously, the job has to, relate to your degree major. The employer has to be verified with E-Verify as well, which is a government program. And you have to apply while you're in OPT period. You can change employers, but again, that your employer has to be registered in E-Verify, which is kind of like an I-9 verification program, but something to keep in mind. And you can check, there's a STEM degree list to make sure your program fits in there on that ICE website. Some common questions while you're on OPT. I'm assuming a lot of you are probably on OPT now, or you're graduating, or you will be next year. Unemployment periods, not everybody's going to be, you're not going to always find the job and be employed for that full period. There will be some unemployment, or there may be some unemployment periods, just to watch out for 90 days, no more than 90 days of unemployment for your regular OPT, and 120 days for STEM 29 months. The best way to avoid the unemployment period would be to actually intern or volunteer. It's like an unpaid internship, basically, for a minimum of 20 hours per week in your field of study. And that way you can avoid the unemployment period. Unemployment would be as if you're not doing anything. So if you can, try and get some sort of internship, 20 hours per week. And since it's not paid, how do you get verification? I would just get a simple letter from the employer saying, this is to verify that so-and-so has been working as an intern with our company for 20 hours per week since March 1st, 2012, something like that. And just keep that for your records. Who knows when you'll need it. And then you also want to make sure you stay in close contact with your International Student Office. Keep them updated with any internships, any volunteering. If you work for a couple days here, a couple days there, you want to make sure that your records are updated with them so that they can maintain your CVIS record properly. For OPT, there is a 60-day grace period once it ends. So, or it's 60 days from the date that you're, if you file a change of status petition, 60 days from that period as well. My parting words about OPT, don't forget to apply. Definitely take advantage of it, whether you plan to return home after graduation, or if you're, feeling defeated because there's no you don't have a job or something like that, and you think that it's not worth it, you should definitely apply, even if you plan to go home, because it's a one-year freebie that the government is giving to you where you get to work. I mean, it has to be related to your field, but it really is, kind of a no strings attached other than a couple of things, opportunity to work for an employer, and you can use it as a stepping stone to find, that employer that will sponsor you, because you can kind of prove yourself, and they'll realize that, they'll never be able to exist without you afterwards. So then hopefully, things will work out, and they'll want to sponsor you for a visa. But also, it gives you that opportunity kind of to see if that is the right fit for you. Just a couple quick things about when to apply. You should always make sure that, obviously, you want to stay within the program end date. It's not your graduation date, but your program end date. 90 days before is the earliest, and then the latest you can file is 60 days after your program end date. You need to check with your school for those exact dates, because the program end dates vary from school to school and from program to program. And you don't want to miss that window, because it is a use it or lose it privilege or benefit that's given to you. So if you miss it, you can't, go back and get it at a later time. And something else that comes up every now and again, especially now that schools are having, a quarterly system, or you can graduate in December, you want to make sure that you map everything out so that if you do have a December graduation, for example, and the H-1B is your ultimate goal, that you time it so that your OPT starts late enough so that, you get to the 1 year. That's, let's say, if your OPT starts February for 1 year, you want to make sure you have to get to that April 1 so you do the H-1B. So it's something to kind of make sure that you plan around. You should talk to your International Student Office about how to apply, because that would be better for you. You don't want to kind of time yourself out, because there are a lot of people who graduate in December who, because they have a job, they start working January. They're January to January, and then once they're done, they have to leave because they don't have any kind of basically carry them over until the H-1B filing period opens. So that's something I wanted to mention there. So, now what? What happens after OPT? You graduate, you do your OPT, things are going well with your employer. Hopefully, what will happen is that they'll want to sponsor you for H-1B. That's probably the most common visa category for individuals graduating. So I'll spend some time there, and also the H-1B cap is coming up. So I'll spend a lot of time on the H-1B category now, and then we'll go through the rest of the visa options that you do have, and then green card at the end. That's the carrot I'm dangling for you guys to keep listening. I'm just kidding. The H-1B, it's a professional occupation visa. It's the job must be one that requires at least a bachelor's degree in that field. So that's something key. It sounds very general, but it's something that has to be a specific degree in the field to perform that job. Some common examples are financial analyst, accountant, software engineer, graphic designer, things of that nature. And there's a whole list of things on the Department of Labor's website where you can go through all the occupations. There's the OOH and ONET where you can look at the different job categories and the requirements for the positions. The H-1B is employer specific, so that means you can only work for the employer that's sponsoring you. You can have multiple employers, or you can work for multiple employers, but you would have to have an H-1B for the additional employers. So let's say you want to work part-time for Xerox and part-time for Coca-Cola or something. You'd have to have two separate H-1Bs. They would be considered concurrent H-1Bs, and it would make the most sense if they were each part-time. You can't hold two full-time positions because otherwise you'd be working around the clock. But that brings me to that point where it can be a part-time H-1B petition. So perhaps some of you are on OPT and the employer doesn't have a need for you full-time, but they do have a part-time need for you. You can do a part-time H-1B. There is a 6-year maximum, and it's granted in 3-year increments. There's an exception to that, which we'll discuss later. So if you're at a certain stage in your green card process, you can continue to extend beyond your 6-year max. It's at-will employment, so that means you can terminate at any time, and the employer can terminate at any time. And the H-1B does have something that in immigration we call portability, which means you can transfer your H-1B to a new employer at any time. You're not subject to the cap again. And once you file the petition, you're eligible to start working for the new employer. Okay, so let's talk about the quota coming up soon here. The H-1B quota, it is based on the fiscal year, which runs from October 1st to September 30th. In case any of you are wondering why all the funny dates with the April 1 and the October 1, it's based on the fiscal year. The quota, or cap as some people refer to it, applies to private employers only. So it doesn't apply to cap-exempt organizations, which we'll talk about in a second. There are 65,000 H-1B visas per fiscal year. And included in that are 5,400 for Singaporeans and 1,400 for Chileans. So it's something to factor in. So there's 65,000 for the bachelor's cap, and then there's an additional 20,000 for graduates with a U.S. master's or higher degree. So U.S. master's, it could be a doctorate or a law degree. There's an additional 20,000 for them. And then last but not least, how early can you file an H-1B? The earliest date you can file is April 1st. I actually just had a call a couple days ago with somebody who was asking, he was like, well, why can't you send it any earlier? You can't. The package will actually be rejected. You can only file, we send it out on the 31st, it gets there on the 1st. Some timing issues, just to give you a brief history of the H-1B, what we used to refer to as March Madness, which it's not meant to induce, panic or hysteria, but it's how our offices, I think a lot of immigration offices were during the month of March, was that there were, everybody's filing tons and tons of petitions, and then an H-1B computer-generated lottery was conducted to select basically the visas, or select the petitions that would be adjudicated, and then the rest are just sent back. So that's how it used to be from 2003 to 2009, and then because of the economy and the downturn and employers unwillingness really to hire and layoffs and cutbacks and all of those things, the H-1B filing period actually got much, much longer. It used to run out that first week of April. We would file on April 1st, and by the 5th, the cap would be met. And then all of a sudden it was opened in April and stayed open until December, which is a huge and drastic change. And so as you can see, for the next few years it was like that, where it would stay open for months and months and months until it shortened finally in 2012. And then last year in April, they announced that the cap was met on April 5th, and a lottery was conducted. So last year was the first time in a really long time that there was a lottery. And we're, signs of a returning economy. Yes, I mean, again, my crystal ball is as good as yours, but it is probably, I think there's a strong likelihood that there's going to be a lottery again because of the economy, and companies are hiring. So for those of you, a practical aspect of that's the timing of everything. Then another aspect of timing is the cap gap extension or provision. This is what applies to all F-1 students. As long as you timely file your H-1B petition, timely means either while you're in your OPT period or you're within your 60-day grace period, you have to file the H-1B during that time in order to extend your F-1 status. So you want to, for those of you who have OPT, you want to file it before your OPT expires, but it has to be after April 1st because that's the earliest date. If you do that, then your work authorization automatically extends through September 30th. And I just noticed. And then if you're in your 60-day grace period, let's say unfortunately, you didn't time out your OPT well, you're in your 60-day grace period, you can continue to be here if you file after April 1st and you're still within your grace period. You can be here until October 1st, but you can't work. So that's where the cap gap extension comes in. And it's only extended until it's adjudicated or September 30th, which is the day before the October 1st. That's as long as it'll carry you. And then if for any reason your petition's denied or rejected, you have 60 days from the date of notification. So here's a little handy chart to kind of give you an idea of the flow and the timing of everything. Let's say you're graduating this June. Congratulations. You have your OPT starting in July. So that'll be 1 year of OPT, which will be valid until July 2015. Next spring, what you would do is file your H-1B on April 1st. Since that's before your OPT expiration, even though your OPT expires July, this would carry you through the rest of the summer until October 1st. And then at that point, assuming your H-1B is selected and approved, your status automatically switches over from F-1 OPT to H-1B. So this is kind of it in a nutshell, and then you would have no gap. For some people, if you do have a gap, you would have to you either have to go home during that period. Some people I know go back to school. They re-enroll, take some classes while they're waiting, or you just kind of have to sit tight. Again, if for any reason there's a lottery and you're not selected, or if for some reason the petition's denied, at that point you usually, unless there's some other issue with your case, usually you have the 60-day grace period from notification. So a quick overview of the H-1B process in terms of the agencies involved. It's USCIS, which is U.S. Citizenship and Immigration Services, and the Department of Labor, the DOL, we commonly refer to. First, for the company, we have to verify the tax ID number, or the FEIN, Federal Employer Identification Number, which is assigned by the IRS. And then once that's verified, we can do the LCA, which we have to submit online. It takes about a week to be certified. So that first step, I would say, give or take 7 to 10 days. And then once that's completed, we can basically hopefully work on all the documents during that time and then submit the application to USCIS, which includes, information about the job and the support letter, the forms, the filing fees, and all of that. Some common RFE issues. RFE stands for Request for Evidence. RFEs are pretty common in the H-1B process depending on the job category. They're more common in some than others. For example, positions like related to sales or marketing, occupations that don't typically require a degree on its face in order to do it. Their argument is, someone with 10 years of experience could probably, be a sales manager or something like that. They kind of challenge it. So it's up to you and the petitioner and hopefully, your lawyer. You guys come together and you kind of, there are ways to kind of describe the specialist nature of the position and why degree is, required and all of that. That's a very common issue. So if any of you are filing, you get an RFE. We call it a specialty occupation RFE. If you get it, don't feel, again, that you're being singled out or you're the only one. It's super common. Another common request is related to VIBE, which is the it's a verification instrument, literally, that USCIS uses to verify the employer, make sure that the company name and the address match up, and it's actually, a legitimate employer. As we talked about before, there is a 6-year maximum on the H-1B. You can have H-1B extensions. The cap doesn't apply to extensions, so you only have to be counted that one time. So if you do it now and you want to extend in 3 years or, down the road, or if you file a change of employer, you're not subject to the cap each time. You don't have to worry about the April 1st timeline or the filing period. You just have to worry about it this one time because once you're in, you're in. There is an H-1B remainder option. So if any of you who, if any of you may have had a bachelor's degree and then had your OPT, did an H-1B for a year or two, and then maybe went back to school to get a master's degree or an MBA and are graduating, what you can do actually to avoid the cap would be to pick up any remaining time. So if you worked for 2 years, for example, you have 4 years left of H-1B time to pick up, and you wouldn't have to worry about the cap. If you want to get a new 6 years, then you would be subject to the cap. Likewise, if you had an H-1B, you're like, oh, I already did my 6 years, but you went abroad and you went to live at home for 2 years, you're eligible for a new 6 years, but again, you would be subject to the cap. A few of these are some new slides about H-1B issues for startup businesses because we've had a lot of questions come up, obviously, with the way that the tech industry is going and apps and, all sorts of, I think, technology that's out there and a lot of great ideas. A lot of people are wondering, can I get an H-1B with a startup? Yes, you can. Let me just say that. Everything else beyond that totally depends on the business plan, the investment, who the investors are, who's running the company, what you'll be doing there. So there are 1,000 other factors that have to be considered, but I just want to give you kind of a quick overview of the types of things that you should, that need to be there at the very least, I think, in order to have a successful H-1B with a startup. And again, USCIS is trying to, update themselves with recognition of startups and entrepreneurs and how the H-1B ties in. But you do have to show the financial ability to pay the salary. So one thing I'm going to talk about in a little bit is prevailing wage, which is a kind of a really key component, and it's a huge issue with H-1Bs is the prevailing wage for the occupation. So you have to be able to show that the startup has enough money to cover overhead, to pay the lease and to pay the phone bills and your internet and your FedEx bills and all of that, and then also to pay the salaries, which includes your salary as well. And you have to show that, that it's a real position that needs to be done by, and it's a professional occupation. Not that you'll be the one who's, answering the phones and then also, also preparing financial reports. You can't, everyone has a little bit of administrative functions in their jobs, but it really does have to be, a specialty occupation, and there should be a place of business, so an office, which is also very important. There has to be a tax ID number. Here's something, you can have a startup where the company is owned by the employee, but there has to be there has to be an independent board of directors where they would actually have the hiring and firing authority and control over the company. But we have to show that the employee does not have control. So it has to, literally you have to have the company be separate from the employee. But it is a possibility. Just a few points, the business plan is really important. I like to submit a really strong business plan if that's available. Usually that's been created anyways and sent out to investors in order to get the funding that's needed in the beginning. So that's usually in place, and within that business plan, financial projections, where is the company going, the more details and information you can give, the better. And then hopefully you're not the only employee. Hopefully there are other employees. That's always a good thing to show that, again, for several reasons. One, the viability of the company. And then two, it's also to kind of show that there are other people there performing some of the other functions. Because again, if you're the only employee, chances are you are answering the phone, you are sending the FedEx, you are doing, other things outside of your role as, the accountant, let's say, or for, whatever it is. Employer obligations, what are they? They are, first and foremost, I talked about this earlier, is to pay the prevailing wage. I provide the link here. You can go and look it up. It's not the easiest website to navigate, but you can look it up. Prevailing wage is paid by your area and by your occupation. So, for example, a software engineer in San Francisco is paid, X. And then if I look up software engineer in, Billings, Montana, it's going to be Y. It's just going to be different based on the metropolitan area. And you have to be paid at least that prevailing wage and as of October 1st. So even if we look it up and we want to file April 1st and that's not what you're being paid now, in 6 months' time, by October 1st, you do need to be getting paid that wage at that point. So that's also a big issue or a common question. They think they have to be paid that now. It's not until October 1st. The employer can't bench you just because it's, slow, and say, oh, we don't have any work for you, so we're not going to pay you. You're a W-2 employee, so you have to be getting paid. Voluntary leaves of absence or maternity leave is fine. If you need to go home because you want to spend time with family for a month or two or something like that, and you put in, I would recommend putting something in writing and putting it in your personnel file so that the employer, I would actually recommend that to the employer, to have that just as record of the leave of absence and that you're requesting it, not that the employer is, again, benching you or kind of putting you off. And then the other obligation they have is that upon termination, they have to offer you a reasonable cost of transportation home. They just have to offer it. You don't have to take it. They don't have to. It doesn't have to be first class. It doesn't have to be, it doesn't include your family members, for example, but they just have to offer that cost of transportation home, and that's if the employer terminates your employment. If you leave, then there's no such obligation. And then the employer is also required to notify USCIS and to withdraw the LCA in the petition. So, again, if they terminate you, they should be notifying USCIS. Portability, H-1B portability, it's where you can transfer your H-1B to a new employer. So, and you can do that at any time, really. Let's say you file and you're there for a few months and you decide, next January that another opportunity has come up or you're not happy or it's just not the right fit. If you do find a new employer, you can file a change of employer H-1B petition. You wouldn't be subject to the cap again, and you would be able to start working with the new employer upon filing of the new petition. So that's nice, and you don't have to pay for premium. Who is responsible for the fees? So related to the fees is, again, the prevailing wage issue. I always think that the employer should pay all of the fees, but I know that's not always realistic or possible. So if you or the foreign national pays any fees, you still have to be paid at least the prevailing wage. So paying those additional fees can't bring you below the prevailing wage. So I give you an example here. Let's say, for example, the prevailing wage for an accountant in Los Angeles is $60,000. That's the level 1 wage. And your salary is $60,000. You can't pay for a single penny of anything, of any of the legal fees or the government filing fees, premium, none of it, because if you do, it would bring your salary below the prevailing wage. Who will know? I make a sad face. You never know. Let's say it's approved and you have to go to the consulate and you have to show your pay stubs and there's some, something there, or if, I don't know, somebody reports you. You never know when and how it's going to come up. But let's say, for example, prevailing wage is $60,000 and you're getting paid $70,000, then you can pay for a portion of the fees. The fees that you absolutely may not, cannot, whether you're paid prevailing wage or not, or above it or not, are the fraud fee and the training fee. They have to be paid by the employer, no reimbursements. The other filing fees, it's not as clear. There's a $325, I-129 fee. Again, I would prefer that the employer pays that. Premium processing, I'm okay with the foreign national paying that, and same with the legal fees. Again, this is all based on you being paid more than the prevailing wage. H-1B audits and enforcement, there have been an increase in fraud investigations and unannounced worksite visits, so that's where a lot of these issues come up in terms of how will anybody know what I'm doing, or checking payroll records. I have, clients regularly call where they have officers stop by and ask to speak with the employee or their HR or the supervisor, and they'll say, what do you do here? And they'll ask you for kind of a description of what you do. They can ask to see payroll records and talk to other people. So if they show up and you're, again, in the file room making copies, or if you're answering the phone, or things that are, inconsistent with what was included in the petition, that's where you could have some issues. And again, the prevailing wage always coming up. For H-1Bs, spouses and children, they receive an H-4 visa. There's no employment authorization, unfortunately. They can go to school. If they do want to work, the spouse would have to apply for their own visa. What happens when you reach the 6-year max? Is 6 years really 6 years? Yes and no. It's kind of a trick question. That is the max, but there are ways you can recapture time spent abroad. So over the course of your 6 years, you guys are just starting out. It's a good idea to keep track of all of your trips abroad, whether it's, you go home to visit family for the summer, or if you go to a wedding in Mexico for a few weeks or a week, whatever it is, or you travel a lot, let's say, for business. You can just kind of piece those time periods together, and you would be surprised. Sometimes it adds up, to 6 months. I've had, clients recapture a year and a half even, which again, usually by the time you're looking at this, you're towards the end, so it really comes in handy. So it's a good idea to keep track of that. And then beyond that, you can extend your H-1B if you're in the green card process, which I have here. Once you have, once the I-140, once the labor cert's pending for more than 1 year, or once you have an I-140 approved and you can't file because of backlogs, you can extend for 3-year increments, and you can continue to extend. But you have to be in a certain place of the green card process. What are some of the myths? I'll just skip through a few of these. Like we talked about, you can do an H-1B for a small company or a startup. Again, if you can show it's a viable company and it can cover overhead and pay your salary, then you can make a strong case with a strong business plan. There's no advertising requirement. I think that's actually one of the biggest misconceptions. That's what the advertising and the recruitment is for the perm green card process, not for the H-1B. There is a posting requirement for the H-1B where the employer has to kind of put up a notice at the place of employment that they're hiring an H-1B worker, but nothing in the paper. You can change employers, throughout your 6 years, whether it's in the first year, second year, 4th year, whatever it is, you can change employers. There's no 10-day grace period after layoffs. If you're laid off, your status terminates immediately. Technically, you only have until midnight of your last day that you're actually terminated formally on payroll records and everything else. You can go to school part-time on the H-1B. That's fine. You can do that. Some people go to night school. One other thing, you can't file under the master's cap before completing the degree. Because of the timing of this, since it's April 1st is the first day of filing, a lot of people won't finish their degree until probably May or June. If you can show that you fulfilled your degree requirements, then you can file under the master's cap. But if you still haven't completed your degree requirements, then you would have to file under the bachelor's cap, and then maybe the following year, if you miss it, you could file under the master's. If you are going to file, and let's say your graduation's in May or June, and you would need a letter from the registrar's office showing that you've completed all degree requirements, and you're just waiting for formal graduation later. And then you could file with that. Premium processing increases your chances of approval. That's not necessarily true. Last year a lot of my cases were premium processing and they were selected. I think it was more coincidence than anything else, but you never know. Technically, on the record, that's not supposed to help. All petitions should be. In terms of selection, I don't know how they do that, but once they're actually reviewing a case, whether it's approved or not, paying premium processing should not increase your chances, no. The next one, yes, of course, somebody can always check if you're working in the H-1B position. So, you want to be careful, and if you're, if your employer is like, oh, nobody will know, it's, fudge it or anything like that, you should be wary of that because they'll probably get some sort of a fine or a civil penalty, but then for you it's a much bigger deal because it could either be unauthorized employment or violating your visa status or something else. So you want to try and work within the regulations. And then the last one, you have to have a U.S. degree to qualify. That's not true. Foreign degrees are okay. So you can, again, for some of you who are maybe here in a bachelor's program, perhaps you had a bachelor's degree from your home country or abroad, you would first want to make sure that it's, it's evaluated and found to be the equivalent of a U.S. bachelor's or a master's degree or whatever. And if you do, then you can use that degree. Maybe there are a couple of instances where that works, where perhaps the job that the H-1B position that you're going for, the degree isn't exactly the degree you're pursuing here in the U.S. Maybe it's more closely related to your prior degree. That kind of maybe opens up the job market or your job options. Or if you're a master's student, and again, because you won't complete your degree until June, you could file under the cap with your bachelor's degree from abroad. Okay, so that was the H-1B. I'm sure you guys have lots of questions. Feel free to email them to me, and I'll try and get to some questions either at the end of the presentation, or what I'll do is I'll try and email responses to each of you as you type them in. I should be able to respond to them separately. But feel free to continue to email them to me now, as you have been. I think people have been posting them on my screen. So okay, the cap has been met. Now what? What are other options? And again, you're like, oh no, not the H-1B. Well, there is the H-1B option for cap-exempt organizations. So that means a cap-exempt organization where the employer is not subject to the cap, so they can file at any time. There's no quota, to worry about, and that only applies to, and they're very specific, institutes of higher education, so universities and colleges, nonprofit organizations affiliated with institutes of higher education, nonprofit research organization, government research organization. The keyword being research, so it's not just a nonprofit organization, but a nonprofit research. I think that's something that people always ask about, and this would be something that's in their, designation, with the IRS. The company would know whether it falls into one of these categories. But it's a great option for those of you who maybe want to, work at a university as an assistant professor or something like that. A quick note, let's say you do that, and then you want to switch, go from university to the private industry, at whatever time you want to switch your H-1B down the road, let's say you're an assistant professor, and all of a sudden Google wants to hire you or something, you're switching to private industry, you would be subject to the cap at that point. Some other options, the free trade agreement visas are great. They're very similar to the H-1B because it's, basically requires a degree in a professional occupation. But again, you don't have the same quota. So there's for Chileans and Singaporeans, it's the H-1B one. They vary. I haven't seen it run out before. And then there's TN, NAFTA visas for Canadians and Mexicans. The TN is really great because there are no filing fees. You don't have to file, and same with the H-1B one, by the way. You don't have to file through USCIS. Canadians can apply at the port of entry, so they can apply at, the airport in Vancouver, pre-flight inspection, and Mexican nationals can apply for the visa at the U.S. Embassy in Mexico. You just have to, schedule an appointment, but you basically go and they adjudicate the TN on the spot, which is really nice. The catch is, you have to check the TN appendix. I give the citation here because it's very specific job or very specific occupations that are on this list, and you have to file, on that list in order to apply for a TN. So even though you're Canadian Mexican, the TN may not work for you, but you should definitely check. It's a great option. And then for Australians, there's the very similar type of visa. It's an E3, which again requires professional occupation and degree, but you can apply directly at the U.S. consulate in Sydney or Melbourne in Australia, and there's no filing. You just actually submit it directly at the consulate. They adjudicate it on the spot. Visa is issued. You enter the U.S. So those are all great options, but just very specific to your nationality. Some other options, there's a J1, and it's, again, pretty specific. There's a J1 for professors and research scholars. A lot of universities offer this as an option. Just, a quick word is to be aware is that some J1 visa holders are subject to the 2-year home residency requirement. So that means, and you would know it, it's indicated on your DS 2019, and it's also indicated on your J visa stamp in your passport. You can't miss it, and you would know this. But basically what it means is that once you finish with your J1 position, you are subject to a 2-year home residency, meaning you have to go home for 2 years and complete this requirement before you can, change your status or adjust your status to a green card or anything else. There is a possibility to waive this requirement, so to apply for a J1 waiver. So that's something, that our office, we have an attorney here who specializes in that. So that is an option, and there's a 30-day grace period at the end of the term on the DS 2019. There's also an H3 trainee. These are, fairly difficult visas, but it's an option. The H3 is for 24 months. It's a 2-year visa. And, this is where sometimes timing for the H-1B is off, or perhaps you have, like an AA degree or something like that. Or it's someone from abroad who wants to come here, but they're coming here for training. And as part of the application, you have to show that the training program is not available in the home country, which, again, a lot of times, as things change, it's difficult to show depending on your occupation or your field. And then you have to show it'll benefit your career abroad, and that you'll have something to go back to once you're done with the training. And again, it's really for training purposes. So that's an option. Some others are the L visas. For those of you who are, entrepreneur, well, more business-minded, I would say, there's the L1A, Executive Manager Visa, and L1B, Specialized Knowledge. The requirement, really, you have to show 1 year of experience or employment with the company, with the foreign company abroad in as an executive manager or specialized knowledge, and you have to be coming to the U.S. to fulfill executive managerial specialized knowledge position. And it's just, a lot of it's based on the corporate relationship of the two entities, the foreign company and the U.S. company. For those of you who've been here, if you're here on a bachelor's, you've been here for 4 years, you can't show this, 1 year in the last 3 years, because it's 1 year in the immediately preceding 3 years. But this may be an option if you have a job opportunity to work for a large company. For example, I don't know, like Nike offers you a job in their Tokyo office. This would be a possibility later. So maybe you could go and work for a year, a couple years, several years, whatever. They could transfer you to the U.S. On this sort of a visa. Again, I'm just using random examples. But this is it's definitely an option. Or let's say you go home to work. If you have your own business or a family business where you've been working for a really long time, you could also be transferred to the U.S. to set up a new office too, which is right here. Startup is, you have to show place of business, employees, that there's money set up, then there's a need for a manager. Again, business plan with strong financial projections is a good idea. That's the new office. I'm just going backwards here, and really quickly for the L1, it's not specific to any particular nationality, so all nationals can apply, and there's no quota. There is and the maximum length of the L1 is for 7 years. If you do the startup or the new office L, it's 1 year initially, and then you can apply to extend it. And then for established businesses, if you do an L, it's 3 years. But again, the maximum is 7. So we just talked about this. If you do a new office, setting up the company, you have to get an office space, a lease, bank accounts, register in the state, get a tax ID, phone lines, all of those things to set it up. It's only good for 1 year, but it's a great option for a startup. Again, if you have, want to go or have a company abroad that wants to set up an established company abroad that wants to set up a U.S. company, this is a good option. and spouses and children receive the L2 visa. The good thing is that the spouses can apply for a work permit. It's an EAD card that also comes similar to your OPT card that comes with for spouses in L2 status. And the L is a really good basis for an EB-13 green card. The next option are the E visas. There's the E1, E2 treaty trade and treaty investor visas for entrepreneurs business. You have to, first and foremost, you have to qualify. Not everyone qualifies or is eligible for the E-visa. There has to be a treaty between the U.S. and the treaty country being your country. So at least, so you have to at least be on that list, and you can check the treaty country list at the travel.state.gov website. At least half of the company has to be owned by the treaty country national. So if you're French and there is a treaty between U.S. and France, you're eligible, and you want to either buy a company or set it up. In terms of the ownership, if you want to have partners, that's fine, but at least half of it has to be owned by French nationals. They can be other nationalities of people that are involved in the ownership, and it doesn't necessarily have to be you, but it has to be half owned by French nationals, if that makes sense. E1 treaty trader, it's for, if you want to do an import-export business, import-export of products or services. Half of the trade must be between the treaty country and the U.S. There's an E2 investor visa. You have to show you're making a substantial investment. Substantial is, their words. They don't give any guidelines based on, the cases we do here. Usually, substantial would be $100,000, $150,000. That money has to be placed at risk. At risk means it's not just money that's sitting in a bank account. It actually has to be spent in terms of setting up the, business, buying. The restaurant's always the easiest. Say you want to set up a restaurant, you have to buy the equipment, the dishes, the plates, the placemats, all of that stuff. That's where all of the money would be spent. You have to show receipts and invoices and things like that. Anyway, so that's a great option if you want to set up a company or you want to buy a business. So for business people, entrepreneurs, spouses and children receive dependent visas, which is great. And then also, like the L, they can apply for a work permit. Spouses can. So this is, again, a really good option for entrepreneurs. O1 visas. So this is for aliens of extraordinary ability. This could be an option if you miss the cap and you're particularly, if you have some good credits or qualifications in business. I wanted to say that. I mean, the O1 is split up into two main categories: science, education, business, athletics, and then O1B, which is in the arts, motion picture, TV. This would be, if you wanted to do an O1 in business, you'd be under the higher category, which is the O1A. The standards are a little bit higher. You have to show, and I've written it here. It's kind of dry. It all kind of sounds the same. But you have to be one of the small percentage who has risen to the top of your field. And then arts and film and TV have slightly lower standards. Or, let's say, again, you want to, for those of you who are in science or education, this would be a great, or it could be a good option. These are just some examples of the types of evidence. The criteria are listed. You can look at them on the USCIS website. But the types of things are, nominations or awards, or if you have memberships, not like you're a card-carrying member like my Costco membership, but like, you were selected, and members are selected because of, their particular achievements in the field. If you have any press about you, or if you have authored or published any materials in academic journals or for newspapers or like a business magazine or Huffington Post, something like that. Your original contributions, authorships, conference presentations, lead critical role for distinguished organizations. So let's say you are the vice president of, this company, and you increased revenues by, $500,000. Those are the types of things that, we could argue in support of an O1, reference letters, things like that. The O1 is a good option because, again, you can apply it any time, but, again, you have to be at a certain place in your career, and you have to have, a substantial amount of evidence about that. Here are just a quick rundown of some job search ideas. I think it's always good to focus on the cultural diversity in the workplace and that we're in a global economy and you're a stronger candidate. You have this, great international perspective and, all of that stuff. But, in terms of where to look, I think your school career services is always a good option. Placement agencies, I don't know what their policies are exactly in terms of international students, but you never know. I mean, you should always consult with them. And then, networking, any events through your local consulates maybe would be a good idea. So that's basically all of your visa options, the non-immigrant visa options. I'll quickly run through green card, and then again, if you do have questions afterwards, feel free to email me. And if for some reason it's taking me a little bit of time to get back to you, please email me again and follow up. It's just kind of, a busy time, but I'm more than happy to answer questions. Green card options, the first thing is the DV, Diversity Visa Green Card Lottery. There really is a lottery. The period is closed now, but it was open. It's usually open like October 4th to November 4th or something. It's a 1-month period that during which you can apply. It's free. You don't have to pay anybody to do it. And so if anybody applied during this last period, you'll find out, I think May 1st, they said that you could log in and check to see if you've been selected. But it's literally, a lottery where they give away 50,000 green cards per year. You have to be eligible to participate. It's based on your country of birth, not citizenship. So I've listed here the countries who are not eligible, and it's only because they've sent more. It's based on the diversity. So we have a high population of nationals from these countries, then they're taken off of the eligibility list. You can cross-charge to your spouse's country of birth. So if you're not eligible based on your country of birth, but your spouse is, then you can both apply under your spouse's country of birth. So if you're eligible, do it. Again, another freebie, just like OPT in a way, that you should definitely take advantage of if you're eligible. Family-based green cards, I'll talk about quickly. Immediate relatives of U.S. citizens. So an immediate relative would be a spouse, parent, or a minor child of a U.S. citizen. They get immediate benefits. I mean, you have to file, obviously, but they will receive a work permit, travel document, usually within about 2 to 3 months of filing. It's pretty quick. I wrote 6 to 8 month processing here. Quite honestly, it's been even less time recently. If it's based on marriage to a U.S. citizen, life happens. You never know what's going to happen down the road. If you, do get married, you can file a green card in this way. Initially, if you're married for less than 2 years, you'll be given a conditional 2-year green card. After that, period, you have to apply to remove the conditions, showing you're still married and all of that. But that's how, that works. And then another super common question is, I have a, U.S. citizen child, and my child was born here. Can they sponsor me? Well, yeah, they can, just not right now. The adult, the child has to be an adult, so they have to be 21 before they're able to sponsor you. So it may be a little bit of time. And then here in red, there was the repeal of DOMA, so same-sex couples are now eligible for immediate benefits, meaning, you can apply for your, assuming that that you've gotten married, you can apply for a green card through marriage to a U.S. citizen. And we've, our office has filed lots of those cases. successfully, and they've been just fine. So that's family-based. That's for the immediate relatives of U.S. citizens, and each of these categories kind of goes down, and it's all based on the visa bulletin. If you go to travel.state.gov, you can look at them and you can see the different backlogs. Brothers and sisters of U.S. citizens having the longest. It's a 12-year wait right now, a 12-year backlog. But I kind of, the analogy is, you just kind of got to get in line and just wait until you're called, kind of like a movie line. You have to get in line at some point. So the sooner you do it, the sooner your number is called. So again, it depends on your situation, but it's just you got to get in line, get a ticket, and then just wait, really. But here are the different categories for family-based. And then quickly we'll switch through employment-based green cards. So this is if you want the employer to sponsor, or if this is done through your employment. EB1 through EB5, employment-based 1 through employment-based 5. So EB1 we call first preference or first pref. Aliens of extraordinary ability, kind of the equivalent to the O1. I mean, the green card version of it. It's, again, a higher standard, so you really have to show you're at the super top of your field because you're able to self-sponsor. So even though it's in the employment-based category, it's based on your kind of occupation, but you can self-sponsor, so you don't need an employer to sponsor you. But again, the standards are very, very high, but obviously a good option and something that you can work towards. You can start building your career, your portfolio, your resume to maybe head in that direction. Included in this are the outstanding researchers and professors. That's EB1-2. Multinational executives and managers, EB1-3, which is kind of like the equivalent of the L visa I was talking about earlier. Again, higher standards but faster processing and wait times. And again, these are for people who have done particularly well, which can be, any of you, maybe in 5, 10 years, 3 years down the line. I have no idea. All it takes is, a major award, and you could be well on your way. The other classifications, the EB2 second preference category, PERM for advanced degree holders. So I'll go through it in more detail in a bit, but that's for, if the job is requiring a bachelor's plus 5 years or a master's degree or higher, falls under this, which is, the PERM for EB2. Sched A Group 2, Schedule A Group 2, alien of exceptional ability in art sciences or performing arts. That's another subcategory. And then the last subcategory in the EB2 preference is national interest waiver. So if you're, doing work which is in the national interest of the U.S., you can apply for a waiver of the PERM requirement. Again, all of this is super technical, but I want to walk you through it just so you have some information. EB3 is third preference, so it's the PERM process, and that's for professionals with a bachelor's degree. Or skilled workers or other workers, they fall into that category, and that's probably the largest category. The PERM-based green card process, which is probably the most common way to apply for a green card through, when the employer sponsors you. Let's say you do your OPT, your H-1B, you're in your 4th year of H-1B, the employer says, you know what, you're great, what can we do to keep you? We want to sponsor you for green card. Then they would probably be the PERM-based process. It's the labor certification process. This is the one where you've all probably heard of, where the employer has to conduct good faith recruitment efforts, show there's no qualified U.S. workers, do the Sunday ads, everything like that. You file it with the Department of Labor. That's the first step. The second step is the I-140 immigrant visa petition. For the PERM, in this process, the employer has to show ability to pay, usually in the form of, corporate tax return or like an annual report for much larger companies. but basically to show that it can support your position, you and your position. The third step, highlighted in red, is the application to adjust status. So this third step you can only file once your priority date becomes current. Your priority date is captured when you file your perm all the way in step 1, and that's kind of the date that you're given, which is what I meant, like in terms of getting in line. As soon as you get in line and you file, the application, you get a date, which is a priority date. Once you're current, then you can receive work and then you can apply and receive the work and travel authorization. Here's a quick snapshot. I meant to update it with the March visa bulletin, which just came out, but here's the February 2014 visa bulletin. It's updated every month on the travel.state.gov website. It's the family-based green card and the employment-based have charts like this, and so I can kind of give you an idea of how to read this. On the left column, you see it's employment-based, first, second, third, other workers, fourth. So that's EB1, EB2, EB3, EB4. And then across the top, you can see the countries. So all countries are lumped into that first. And then China, India, Mexico, and Philippines, due to the high volume of immigrants from those countries, they have their own visa availability numbers. And so as you can see, the C's all mean current. So if you're that means that category is current. So everybody who files an EB1, the extraordinary ability one, that's all current, so it gets processed, immediately. EB2 for all countries except China and India are also current. EB3, that's where it starts to get a little different, 2012. So that means, there's a 2-year wait time. And then, like, you go to India, for example, there's a 10, 11-year wait time, Philippines. So you kind of have to check this every month. It'll all of a sudden jump ahead. We'll get 1,000 crazy frantic phone calls, like, oh, I'm so, we got to go. So it changes. It goes back and forth. So it's something to keep track of. But I put it here. You can always check to see where you stand. For the perm, as you can see, we'll go back between the difference between EB2 and EB3. Right now it isn't actually too much, but EB2 is current. Depending on your nationality or your country of birth, which it's based on, by the way, not your passport, but your country of birth, it may be beneficial. You want to file in the best category possible, but it's not up to you. It's not based on you. It's based on the actual minimum requirements for the job. So even though you have a master's degree, doesn't necessarily mean that the job being sponsored by the employer in the perm has to have somebody with a master's degree to be that, the market research analyst or, whatever it is. Some tricks that don't work, you can't really tailor the minimum requirements to your experience or education. You can't have a foreign language requirement unless it's truly a requirement for the position. Let's say if you're a translator of technical documents, then obviously you would need a foreign language. But just to conduct day-to-day business, you may not. I mean, again, these are specific things that we would talk about, but that's something to be careful of because they're considered red flags with the Department of Labor, and you may be, which would trigger an audit. Possibly, there are a few things that would trigger an audit. Once you get audited, it becomes a difficult process. So. And for the most part, unless you can show the jobs are different with the employer, you can't use that same experience, which is something that a lot of people are not aware of until it's too late. They graduate and they start their H-1B with this employer, and then they start the green card process, assuming that all of this experience can be used. And a lot of times, if it's in the same job, it can't be used. So then the requirement is just, somebody with a bachelor's degree. You can't say bachelor's degree plus 4 years of experience because that 4 years was gained with that employer unless you can show you had 4 years before the employer. Anyways, I'm getting way too technical. When should we start? About 4.5 years into the H-1B process. It does take some time. You want to make sure you like your employer and vice versa. some other green card options. There's a EB-4 religious worker visa and a green card. Well, it's a green card option, really. EB-5 is $1 million investor green card or a $500,000 investment into the regional program. They're very specific, but the $1 million one is if you want to actively create your own job and be active in the running of the company. You have to create 10 full-time jobs, which sounds easier than it really is. The EB-5 Regional Center program's $500,000. It's a pooled investment, so it's much more passive. In case that's what you're looking at, these are some technical, I think, requirements for the EB-5 that I'm going to kind of skim through. But you just have to decide, if you want to be a passive investor or if you want to be more actively investing. Again, this is if you're, you have the resources. You have to show where the money comes from, if it's going to be from the sale of some property or a very generous family member or something like that. The EB-5 is an option, and it's, for the green card, which would be great. Okay, I think I've successfully completed all of the slides. What I can do, since we've run out of time, is answer your questions. I'll print them out and try and respond to everybody by email. If you do have follow-up questions, again, my name is Fuji Whittenburg. My email address is here, fwhittenberg@wolfsdorf.com. We have offices here in Los Angeles and an office in New York. You can sign up for our newsletter, and you can also sign up for additional webinars. I'll be conducting the same webinar again next month, so you can register for that again. And we can also, I'm getting a lot of questions about the PowerPoint. I can go ahead and share that as well. If you can also contact the administrator of this, and we can get the PowerPoint out to you guys. But again, if you have any questions, please feel free to let me know. Thank you so much for registering. I really do appreciate your time, and I hope that you found this useful. Feel free to give any feedback to me directly. I would appreciate that as well. Thank you. Have a great afternoon.